I noticed the silence first. Not the peaceful kind, the wrong kind. The kind that makes you stop mid-step because something familiar isn't there anymore. The tree should have been visible from the driveway. It always was. A massive oak that predated the house, the road, the HOA, and just about everyone who currently had an opinion about it. 200 years old, according to the arborist report my grandfather had framed decades ago. That morning, there was nothing above the fence line. Just sky. I walked faster, already knowing what I was going to see, but hoping I was wrong. When I reached the spot, the air smelled sharp and green, fresh cut wood. The ground was littered with sawdust, tire tracks pressed deep into the soil. Where the oak had stood was a stump. Clean cut, level, deliberate. For a moment, I didn't react. I just stood there, staring at the growth rings exposed like a cross-section of time. Each ring a year. Storms, droughts, wars, generations. Gone in an afternoon. I checked the fence. Still intact. The tree had been entirely on my side, always had been. I knew that because I'd paid to confirm it years ago when the HOA first complained about falling leaves. My phone buzzed. An email notification. Subject line. Routine maintenance completed. It was from the HOA. The message was brief, almost cheerful. They informed me that hazardous vegetation near a shared boundary had been removed for community safety. No apology. No question. No mention of permission. I scrolled back through my inbox. No warning. No notice. No vote. Just action. I called the HOA office. Straight to voicemail. I drove to the management company instead. The receptionist smiled politely and told me the board president wasn't available. When I asked who authorized the removal, she hesitated, then said a name I already expected.
Karen.
She'd been after that tree for years. First, it was the leaves, then the shade, then the liability risk. She'd claimed branches might fall during storms, even though the tree had survived 2 centuries of weather just fine. I'd told her no every time, firmly,
Calmly.
in writing. I asked the receptionist if the HOA had an arborist report declaring the tree hazardous. She said she didn't think so. I asked if they had my written consent.
She said no.
I asked if they were aware the tree was on private property. She said, I assumed. That word again. I left without raising my voice. Back at the house, I took photos.
Dozens of them.
The stump, the tracks, the saw marks, the boundary line, the fence. I pulled the old survey from my files and matched it to the ground with a measuring tape. The tree had been more than 12 feet inside my property line. There was no ambiguity. By afternoon, Karen finally called. She spoke like this was already settled. We had to remove it, she said. It was a risk. I asked what risk assessment she used. She said, common sense. I asked why I wasn't notified. She said, it's part of HOA maintenance. I reminded her I wasn't subject to HOA rules for that parcel. She paused, then said something that told me everything I needed to know. Well, the community can't just be held hostage by one person's tree. That was the moment the situation changed. Because this wasn't about safety. It was about authority. I told her I'd be filing a formal complaint. She laughed, actually laughed, and said, good luck proving damages. I looked back at the stump, at 200 years reduced to a flat circle of rings. And for the first time that day, I smiled. Because Karen had just made a very expensive mistake. She just didn't know it yet. Karen thought the tree was yard debris. The law didn't. The next morning, I called an arborist, not the kind the HOA used for trimming hedges, but a certified specialist who handled historic and protected trees. He arrived with measuring tools, soil probes, and a camera that made the stump look like evidence at a crime scene. He didn't rush. He counted rings, measured diameter, checked the surrounding root zone. Then he asked if I had photos of the tree before it was cut. I showed him. His eyebrows lifted slightly. You know what you had here, right? I have an idea, I said. He nodded. This wasn't just mature. It was legacy. He explained how value is calculated not by firewood or lumber, but by replacement cost, environmental impact, age, and irreplaceability. The older the tree, the less replaceable it became. At a certain point, values stopped being theoretical and started being legal. 200 years crossed that line. He wrote the report over the next few days. When it arrived, the number at the bottom made me reread the page twice. $1,037,000. Not sentimental value. Not punishment. Replacement and damages. I forwarded the report to my lawyer. She called me 10 minutes later. They cut it without permission? She asked. Yes. On your property? Yes. No easement.
No.
She exhaled slowly. Then this is not an HOA issue. This is trespass and destruction of property. She explained something Karen clearly didn't understand. Trees aren't fixtures. They're assets. Especially old ones. Especially documented ones. Especially when they're taken without consent. We sent a demand letter to the HOA that afternoon, attached with the arborist's report, photos, and survey. It wasn't threatening. It was factual. It gave them two options: accept responsibility and settle, or contest it in court. The response came faster than expected. Karen replied directly. This number is absurd, she wrote. No tree is worth $1 million. My lawyer's reply was shorter. This one was. The HOA's tone shifted overnight. Emergency board meeting. Multiple emails. A request to discuss alternatives. They suggested planting new trees. Landscaping credits. Reduced dues. None of that replaced a 200-year-old oak. And none of it addressed the core issue. They'd crossed onto private land and destroyed something they had no right to touch. The law didn't care that they thought it was unreasonable. It cared that it happened. Karen called again. This time, she wasn't laughing. She said the HOA would review the matter internally and asked me to hold off on legal action. I told her the clock was already running. That evening, I walked past the stump again. The sun hit the exposed rings just right, highlighting every year the tree had stood while people argued nearby, built houses around it, and assumed permanence without understanding it. The tree was gone. But its value, its real value, was finally being seen. And the HOA was about to learn that some things cost far more than they look. The HOA didn't accept the number. They attacked it. Within days, they hired their own arborist, one who'd never seen the tree standing, only the stump. His report was shorter, vague, and carefully worded. It described the oak as overmature and suggested its removal had been inevitable. I read it once and set it aside. My lawyer wasn't impressed. He evaluated what was left, she said, not what was destroyed. The HOA's attorney sent a letter next. It was dense with legal language and thin on substance. They claimed implied authority, community safety, and emergency action. They cited HOA bylaws that didn't apply to my parcel and referenced neighbor complaints without attaching a single one. We responded with the survey. The certified arborist report. Photos. Emails where Karen explicitly acknowledged the tree was on my land. That last part mattered. Because intent doesn't need to be malicious to be costly, it just needs to be negligent. The HOA tried a different approach. They reached out through neighbors. People stopped me on the street, suddenly concerned. They told me the HOA's insurance would never cover that amount, that I was hurting the community, that we could all move on if I let it go. One man said, "It's just a tree." I didn't argue. I just said, it was mine. Karen sent another email. This one was defensive. She claimed the tree posed a clear and present danger and that immediate action was required. When my lawyer asked for documentation of that determination, they sent photos of branches on the ground after a storm. None of them were from my tree. We filed suit the following week. Not because I wanted a courtroom, but because they'd left no alternative. The filing was precise. Trespass. Destruction of property. Damages.
Costs.
The HOA's insurance carrier got involved immediately. That changed everything. Suddenly, Karen wasn't the loudest voice in the room anymore. The adjuster requested documentation. The board requested meetings. The attorney requested time. They offered a settlement.
Low.
Insulting. Framed as a favor. We declined. The insurance company ordered an independent appraisal. A real one. The appraiser spent hours on site, reviewing photos, reports, and soil data. He confirmed what the first arborist had said. The tree's age, location, and condition made it irreplaceable. His valuation came back slightly lower. $940,000. Still devastating. The HOA went quiet. Karen stopped emailing. Then, 2 days before the hearing, the offer came. Full coverage of damages. Legal fees. Removal of any HOA claim over my property line. All contingent on one thing. A confidentiality clause. I told my lawyer no. She raised an eyebrow. You're sure? Yes. Because this wasn't about money anymore. It was about precedent. And the HOA was about to learn that silence can be more expensive than truth. The courtroom was smaller than I expected. No dramatic wood paneling. No raised voices. Just a quiet space where facts carried more weight than confidence. Karen sat 2 rows ahead of me, shoulders tense, whispering to the HOA's attorney. She didn't look angry anymore. She looked tired. The judge entered, everyone stood, and the room settled into something serious and exact. This wasn't a neighborhood dispute. This was property law. The HOA's attorney went first. He talked about safety, about storms, about responsibility to the community. He framed the tree as a risk that had been regrettably necessary to remove. He emphasized intent, how no harm had been meant. When he finished, the judge asked one question. Did the HOA have written permission to enter the property? The attorney hesitated. No, Your Honor. Did the HOA own the tree?
No.
Was there an easement or emergency order?
No.
The judge nodded once. Proceed. My lawyer didn't dramatize anything. She laid out the timeline, the emails, the survey, the arborist reports. She showed photos of the tree standing, then the stump. She highlighted Karen's messages where she acknowledged the tree was on my land and still approved the removal. She didn't accuse. She demonstrated. When the arborist testified, the room went very quiet. He explained age, valuation, and why replacement wasn't a matter of planting another tree somewhere else. You cannot replace 200 years, he said simply. The HOA's arborist was called next. Under cross-examination, he admitted he'd never seen the tree standing, never reviewed historical photos, and never evaluated root spread beyond the stump. The judge thanked him and made a note. Karen was called last. She tried to sound composed. She said she believed she was acting in the community's best interest. She said she didn't realize the tree's value. She said she thought HOA authority extended to the boundary area. The judge asked her one question. Did you verify ownership before ordering the removal? Karen paused.
No, she said.
That pause was expensive. After a short recess, the judge returned with a ruling. The HOA was liable for trespass, for destruction of property, for damages as established by the independent appraisal. The total came just under $1 million, plus legal fees. Karen stared straight ahead as it was read aloud. The judge declined the confidentiality request. This matter serves as a cautionary example, she said. Property rights are not suggestions. That sentence ended the case. Outside the courtroom, the HOA's attorney approached my lawyer with a handshake and a tight smile. Karen walked past without looking at me. I didn't feel triumphant. I felt settled. The money would be paid by insurance mostly. Premiums would rise. The HOA would reassess its authority. Karen would no longer be president by the end of the month. All of that was predictable. What wasn't predictable was how quiet it felt afterward. No more letters. No more calls. No more assumptions. Just a cleared space where something old had once stood, and a boundary no one would cross again without checking first. Justice hadn't been loud. It hadn't been emotional. It had been methodical. And it had worked. The check arrived 6 weeks later. No ceremony. No apology. Just a number printed neatly on a piece of paper that could never grow leaves or cast shade. Insurance money, filtered through lawyers and procedures, meant to make a loss hole that couldn't actually be replaced. I deposited it and didn't feel richer. I felt finished. The stump was removed shortly after. Not because I wanted to erase what happened, but because leaving it there had started to feel like letting the HOA decide how long the damage stayed visible. I kept a cross-section of the trunk, polished and sealed. 200 rings, each one marking a year the tree had stood while generations came and went around it. It hangs in my office now, not as a trophy, as a record. The HOA sent a final letter acknowledging the judgment and confirming, in writing, that they had no authority over my property beyond the clearly defined boundary. The language was careful, almost apologetic, but it said what it needed to say. They would not overstep again. Karen resigned quietly. No announcement. No farewell email. Her name vanished from the board listings like it had never been there. People stopped bringing her up in conversation, the way they do when a subject becomes uncomfortable. The neighborhood adjusted. New rules were drafted. Procedures added. Verification of ownership became a line item no one skipped anymore. Contractors were told not to touch anything without written consent. Lawyers were consulted before decisions were made. All because of one tree. I planted a new oak near the original spot, not as a replacement, but as a continuation. It will take longer than my lifetime to reach what the old one was. That's fine. Some things aren't meant to be finished by the people who start them. Every time I water it, I think about the mistake Karen made. Not cutting down the tree. Assuming she could. The law didn't punish her for being wrong. It punished her for not checking. Because authority doesn't come from confidence, or majority opinion, or convenience. It comes from records, boundaries, and respect for what isn't yours. 200 years of growth was reduced to sawdust in one afternoon. And it cost nearly $1 million to learn what should have been obvious from the start. Some lines aren't suggestions. Some trees aren't replaceable. And some lessons are written quite literally in the rings. Quiet justice doesn't shout. It just stands there, counted and undeniable, waiting for someone to finally read it.